Good afternoon, and thank you everyone for attending today's webinar, Out-of-Network Consumer Protection, Transparency, Cost Containment, and Accountability Act, presented by Sheila Mintz of Capehart-Scatcherd and Susan Lieberman of Conventus. Please be aware that there will be a question and answer portion today at the end of the webinar. To avoid frequent interruptions during the webinar, please type your questions in the question box located on the right of your screen. They will be answered in the order received during the question and answer portion. Additionally, an electronic version of this presentation will be emailed to all participants following completion of today's webinar, and a recorded version will be available on the website for members only. Don't forget that our Payer Day will be held this Friday, November 30th, and next Friday, December 7th. This Friday in Edison, next Friday in Deptford. If you need help registering or have any questions, please contact us in the office. Again, we would like to thank you for attending, and I'll now turn things over to Sheila and Susan.
Good morning, or good afternoon, I guess, everybody. I'm Sheila Mintz from Capehart-Scatcherd. There's some information about us in the, and I'm here with Susan Lieberman, who's the Vice President of Conventus Insurance. You could explain how the name works. Anyway, Conventus Insurance Exchange. Just before we get started, I wanted to put in like a general disclaimer that we're going to describe what's in the law, which is fairly complicated, but generally neither one of us, the information should not be construed as being actual advice to you or any of you related to what you should be doing or what you shouldn't be doing. You would really need to contact your own counsel, or to find out because every situation is different and they're all very fact sensitive. So you have to just be careful to make sure that you don't take what we're telling you as the final word on any particular problem that you may have in the office. That's us. All right, so I'm just going to do an overview of the law. Basically, the out-of-network law is very long. It was title's long. So it was signed on June 1st and went into effect on August 29, 2018. It only applies to state-regulated insurance plans. It does not apply to federally regulated or self-funded plans, which is about 70% of New Jersey's market. So the state-regulated is about 30%. The self-funded and federal is about 70%. As you say later, though, the self-funded plans do have the option of opting into the coverage for the out-of-network bill. And so that you have to be careful about making sure that if someone presents you with insurance, that they in fact are, that they are in fact not covered by the OON bill, or they are. So if they're self-insured, particularly. So it's all right. The coverage of the act is pretty broad. And, obviously most of these people, everybody here is probably a practice manager or with a practice. So we don't need to talk too much about the hospitals and what the hospital requirements are. But generally the bill covers all of the different hospitals, emergency departments, ambulatory care facilities, ambulatory surgical facilities, and most importantly for you, our listening public, the healthcare professionals acting within the scope of their licensure. So it would not just be a physician, but it would be also include nurse practitioners and physician assistants. The insurance carriers are subject to the Act. Again, state-regulated insurance plans, whether they're HMOs, medical service, multi-employer welfare arrangements, state health benefits, or school employee health benefits, all of those carriers are subject to the Act. So it's really going to have to be something for everybody to figure out when people come in. The ones that are not included are self-funded plans that are not included in the definition of a carrier. Again, the self-funded plans can opt in to participate, and if they're going to opt in, they have to notify the Department of Banking and Insurance of their intent to opt in and issue a health insurance identification card, letting to the primary insurer, indicating the plan is self-funded and has elected to be subject to the Act. So this way, you know, if someone comes into your office, that they in fact are in a self-insured plan and that they are also have opted in for coverage under the Act. So, I mean, really the only way you can know what is self-funded to have opted in is to look at the card when they come in and to make sure that you have your procedures and everything as set up as tightly as possible within the office, so that you understand that you have to go and check some of those things. So all of these plans are plans that are not covered by the out-of-network plan. So generally Medicaid, Medicare, accident, disability plans, long-term care. So there's a whole list of those of which are not covered. So PIP, obviously, workers' comp, also not covered. So those are things you don't need to be too worried about. But you know, there are, but you do need to be concerned about what the private health carriers are doing. So basically what the Act does is requires providers to disclose their network status. So you have to put on your website. Generally, it's better to put it on the website because then you don't have to make sure that you're handing out pieces of paper to people when they come in. So you have to disclose your network status. You have to not just disclose at the carrier level, but you have to actually disclose the type of plan that you are participating in down to the plan level. So if you have a Horizon HMO, Horizon EPO, Horizon POS, you have to put in all of those things on the website. And then you can, and then that will be providing complete information under the Act. And you should be aware that this would not just cover providers who mostly provide emergency or trauma out-of-network services, but also just basically any provider needs to have this available. Also, it's really important to know that there's a misrepresentation. You can't balance bill patients. You can't misrepresent network status, and relates also to the emergency or urgent services at an out-of-network facility, and receipt of inadvertent out-of-network services at an in-network facility. So, I think we know what emergency services are, because that's defined by EMTALA. Urgent services are not really well defined anywhere, but generally, I think it's the idea that the physician feels that the person needs to receive services within 24 hours, of their presenting at the practice or at the hospital. And then the receipt of inadvertent OON services, which would be basically if it was a surgery and it was an in-network surgeon, but the anesthesiologist, the radiologist, the pathologist, any one of those providers would not be in network, then that protects the patient in the event of against balance billing. So the penalties are fairly stiff. You can see it's $100 per violation. Every day that the violation occurs would be a separate violation, so it's going to start accumulating pretty quickly. But no healthcare professional would be liable for a penalty greater than $2,500 for each occurrence. But each occurrence is, it could be by patient, or it could be, there's various types of occurrences that could happen. So it could run up into a significant amount of money, and also result in a report to the licensing board. If it's a healthcare facility or carrier, then the penalties are $1,000 per violation, and then the same type of thing, but the larger penalties of up to $25,000 for each occurrence, and a report to the Commissioner of Health.
Okay, this is Susan Lieberman. I'm the Vice President of Practice Resources at Conventus Insurance Exchange, which is a medical professional liability insurance carrier and medical malpractice insurance company here, domiciled here in New Jersey. Before we go into the disclosure in greater detail, I just wanted to say with the penalties that you should know your providers incur insurance coverage for board actions in defense to see if they are covered should there be a complaint lodged against your provider that he or she has violated the law. The other thing is that it is possible some other possible exposures may be in the future billing fraud and abuse for failing to comply with the law. So you want to check regarding your fraud and abuse coverage as well. So now I'm going to go into disclosure requirements as it impacts physicians in our offices. We won't be going through this law regarding the implications for hospitals and other healthcare facilities such as ambulatory surgical centers, although the law does have provisions for them as well, but we're really just focusing on physician offices today. And the first thing that we're going to talk about is disclosures for non-emergency services, and then we'll go into emergency services. So the first thing that Sheila has already said is that prior to scheduling an appointment, the patient has to either be directed toward a website that lists, your participating health plans, and or in writing. If you don't have a website, then you're going to want to put it in writing, put a list in writing, put it up in your office as well, and you're going to have to send it to the patient prior to their arrival, because it has to be either on a website or in writing, and it has to be updated on a timely basis. And then again, you have to tell the patient at the time of appointment by listing the participating health plans and the facility affiliations. This can be done either verbally or in writing at the time of the appointment. We suggest that you have it in writing so that the patient doesn't say, "You never told me," and you will see that there are consequences for that. There are monetary consequences for that. And just understand that this is down to the specific plan level. You can't say, "Oh, I participate in Horizon or Aetna or United," or whatever it is. It is down to the specific plan level, as Sheila has already said, and it has to be in language that the patient can understand. One of the things that we do hear quite frequently is that, "Oh, I'm a physician, I'm totally out of network, so I don't have to do anything." No, you do. You have to disclose that on your website, as well as the facilities that your physician has affiliation with. So
let me just add one thing. I've also heard from a lot of practices that I work with on, they say, "Well, I'm totally in network, so I don't have to disclose either." And that actually is not the case, because even providers, even practices where you do accept most of the insurances, there are very likely to be some levels of plans that you don't accept. So you have to really have that information available on your website and in writing or verbal. I agree with Susan 100% that everything should be in writing, because then people can't say if you didn't tell them. But this really is across the board for every practice.
Thank you, Sheila. That's a very important point. We're hearing that too, that practices and physicians and practice managers are saying, "Well, I just take everything." Well, you can't possibly just take everything. You still have to comply with the law. Thank you for that. So what do you have to disclose? We're going to go into it in a little greater depth and a little later, but just to let you know that you have to disclose whether you're in or out of network down to the plan, and the patient can request the estimated amount that they will be billed. If they request that, what you also have to give them is the associated CPT codes and their responsibility to in excess of either their deductible, their copay, or the co-insurance, and also recommend to the patient that they contact their health benefits carrier to understand all the costs associated with the out-of-network status of their provider. So we went through, I think there's one other
did I get
slide? Yeah.
No, we did that one.
Okay, so there should be another slide, but if not, I'll just talk to it.
Okay.
Okay, so the next one will be for procedures in the office. Let's see if it's the next one. Okay, out of there. It'll be procedures in the office that your physician might perform, or coordinated by your office, or referred or coordinated of the referrals by the office. This is for office-based procedures that you might be doing. And you might have, other providers such as anesthesiology, pathology, radiology, laboratory, assistant surgeon. If you're coordinating all of that as part of an office-based procedure, you must provide the practice name, the mailing address, and the telephone number of each one of those providers. Again, the law specifically said anesthesiology, pathology, radiology, laboratory, and assistant surgeon. But anybody that, any licensed professional that you've coordinated services with, you need to let them know how to find out whether they are in or out of network, and their contact information, provide them with that instruction, and recommend that they contact their health benefits carrier for consultation on any costs that they may incur. If you are a primary care physician or you're an internist and you perform an unscheduled procedure in the office, such as you're doing drainage of an abscess, or you're removing a mole or a wart or something like that, the required disclosures may be verbally at the time of the service, because you didn't know beforehand that you were going to be doing this particular procedure. Okay, now what is that? Now, okay, so now we have done in-office visits, we've done procedures in the office, and now we're going to go to scheduled facility service, either as an inpatient or an outpatient. So the provider has to provide the patient with the facility with the name, the practice name, the mailing address, telephone number, et cetera, of those physicians whose services will be arranged by your physician and who are scheduled at the time of pre-admission, registration, or admission. Again, you have to provide instruction by giving them all of these contact information, and again, recommend that they contact their health benefits plan carrier for the costs that they may incur. If your provider if your network status changes between the time that the patient scheduled the procedure and the time it is performed, then the patient needs to be informed. So here's some action items that we think that you should be taking in your office, because what we really want to do in this webinar is give you some practical suggestions of how to start to implement this law, because it is complex and it can be overwhelming. So the first thing that we would suggest is that you have one person coordinate and manage the overall process, and it really should be somebody who knows your revenue cycle management and how that works in your office. One of the things that we have been hearing from our practices is that, oh, my billing company is taking care of it. Well, your billing company can't, first of all, you don't necessarily know that your billing company is up to date on all the aspects of the law. But secondly, that there are things that you have to do in the office separate from the billing company, such as all the disclosures that we're talking about. So you really can't leave it just to your billing company. It really you have to take an active role in this, and the physicians have to take an active role in it because they're going to have to make certain decisions, which I'll talk about a little later, such as what your financial policy will be and what financial hardship would be considered in your office. But I'll get into that a little later. We recommend that so you can't say I participate in everything, and you can't say I participate in nothing. I think Sheila and I have really honed in on that. But you really need to review the health plans that you're participating with, and remember again that it is down to the specific plan level. The other thing is that you need to review your financial forms, and specifically we strongly suggest that you have a disclosure form. Now, the state licensure boards are supposed to come out with some sort of template and form for disclosure, but we have no idea when that may happen, and the law is already in effect. So we suggest that you develop your own disclosure form, and a little later we will go through what we suggest in that form. And for our Conventus members, we've already given them a template, but we will guide you in some of the basics of that. You might want to incorporate it into your patient registration packet, and not just for your new patients. It's got to include the out-of-network law language, and we highly suggest that you obtain the patient's signature because they have to knowingly and voluntarily choose you as an out-of-network provider. And the law specifically says knowingly and voluntarily. In a little while, I will give you the definition of knowingly and voluntarily when I start to go through what has to be on that disclosure form. But just know that if they do not knowingly and voluntarily, if you don't knowingly and voluntarily disclose, the patient doesn't have to pay the balance of the bill. So that is something that you need to know. And you also need to know that sometimes, your patients may change their plans. So this is something that you have to keep up to date on. We also suggest that you educate your staff and develop some type of script for your schedulers and front desk because they need to know what to say when a patient calls and wants to set an appointment or needs a referral or needs to schedule a procedure. So, for example, you're going to want to say that whether you do or don't participate in their plan, what their financial responsibility would be and their copay, that they can contact their health benefits plan regarding charges, and would they like to know the billed amount. So those are some of the things that you might want to have in the script. The other things are, obviously, you're going to ensure that your list of carriers and health plans are kept up to date and train your staff so that they know what it is. Again, it is down to the plan level, and you're going to also have to update your website. And if you have it in a list because you don't have a website and you have it in writing, you're going to have to frequently update that as well. Next, if you have privileges at a facility, a healthcare facility, they're supposed to notify you of the provisions of the Act as it pertains to the hospital or the healthcare facility and your physicians, so that you need to make sure that you know the health benefits plan the facility has as whether or not they're an in-network provider, and communicate any changes that you may have to the healthcare facility. Now we're going to go through some of the patient holds harmless and balanced billing prohibitions. And remember I told you about the definitions of things like knowingly and voluntarily and all of that. And you really need to know these definitions in order to understand the law and how to implement it. So knowingly, voluntarily, and specifically, this is the exact wording in the law, selection of the out-of-network provider, basically means that the patient chooses the specific provider with full knowledge that the provider is out-of-network with regard to their health benefits plan, and that they had a choice to go with an in-network provider and chose not to. And disclosure by a provider just of network status does not render a covered person's decision to proceed as a choice made knowingly. So just because you say, oh, I'm out of network, again, you're going to need that disclosure form and specifically what is on that disclosure form.
Yeah, I just wanted to add one thing that I've had a number of people say to me, well, you know, we have these assignment of benefit forms and that should be fine. And it's really not fine because if you're, you know, if you do a lot of out of network procedures and what have you, if you just have your regular assignment of benefit forms, that does not demonstrate the level of knowingness and voluntariness that the statute provides. You really want to make them as ironclad as possible so that someone can't say, oh, I didn't realize, oh, I didn't know, you know, and that's where you're gonna run into trouble.
Thank you, Sheila. Sheila already talked about what emergency and urgent services are. Emergency services basically refers to the EMTALA definition of it, but I'll just say that basically it's anything that's life-threatening and needs immediate medical attention. And I've given you on the slide some of the things that the law specifically says. The law did not define urgent services. So Sheila and I have spoken to physicians who are like, well, what does urgent services mean? I'll make everything either urgent or emergent, especially if they're dealing with emergency departments and procedures that may need to be done in the emergency department. While this is not formal yet, the New Jersey Department of Banking and Insurance has put out proposed guidance. And in that proposed guidance, they did better define urgent services. And they're saying anything that's non-life-threatening that needs care or procedure within 24 hours rather than immediately. So if your physicians go to an emergency department in the ER and they do procedures, this is something that they might want to think about, what they consider urgent and emergent based on the definitions in the law and this proposed guidance. The other thing is, as I believe Sheila already said about the inadvertent out-of-network services, and it's basically if the patient is seen at an in-network facility, but some of the providers are out-of-network because there's nothing else available except an out-of-network provider, such as an anesthesiologist, radiologist, or pathologist. Okay, so now let's see how this applies, okay? Remember, we keep on saying, unless the covered person at the time of disclosure has knowingly, voluntarily, and specifically selected an out-of-network provider, unless they've done that, then you can't balance bill them. Okay. This specifically applies to non-emergency services, not the emergency services. So you can't attempt to collect or bill for the in excess of the copay or the deductible or the co-insurance if the patient has not consented to what is considered knowingly and voluntarily. Okay, what do we do now for emergency, urgent, or inadvertent services? Again, we've said that the out-of-network provider cannot bill a patient in excess of the copay, deductible, or co-insurance for all those things defined as urgent or emergent or inadvertent. But they can, and I want to stress that, can bill the carrier for that excess amount. You can't bill the patient, but you can bill the carrier. And there is a process that Sheila is going to go over later on the arbitration process. If the disputed amount between what you billed and what the carrier wants to pay you is equal to or greater than $1,000, there is an arbitration process. So, how does this all affect the physician's office? Remember we said we want to make this practical for you. And some of the things that we think that you should put on this disclosure form is create this non-emergencies, that you're in or out of network. You need to let them know that in regard to their specific plan, the estimated charges, the associated CPT codes, the patient financial responsibility, so that they would be responsible for anything over the deductible, copay, or co-insurance, and the excess amount allowed above the amount that the health benefits plan will pay. And again, it's the same wording, that the patient needs to contact their health benefits carrier, direct them back. There's an acknowledgement statement that the patient knowingly, voluntarily, and specifically selected the out-of-network provider, and there should be a patient signature and date on the form as evidence of this. Sheila already started to mention assignment of benefits and waiver of copays. We're talking specifically about emergent, urgent, and inadvertent services as it is defined by the law. Inadvertent services or urgent or emergent services, once the benefit is assigned by the carrier, is supposed to be paid directly. The reimbursement is supposed to be paid directly by the carrier to the out-of-network provider, so to your provider who's out-of-network. Nothing's required by the patient for this, but the carrier needs to provide you, the out-of-network provider, with a written remittance of the payment that specifies the proposed reimbursement, the deductible, copay, or co-insurance owed by the patient. Now, the law specifically says that you can't entice patients to use out-of-network providers if there are in-network providers available. So that means they're saying that you can't directly or indirectly rebate, give, pay, or waive or offer to waive the deductible, copay, or co-insurance, or any of those kinds of possible scenarios. However, the New Jersey Department of Banking and Insurance did further clarify this. Again, this is a proposed guidance. We have not heard that this has been made into a formalized guidance yet, but it is a proposed guidance. The out-of-network provider may waive, rebate, give, or pay to offer, or pay or offer to waive, rebate, the deductible, copay, and co-insurance if it's not offered as part of an advertisement. So you're not saying, I'll give you 50% off. The out-of-network provider doesn't waive routinely, so that there's no trend that you're always waiving these copays. You're making good faith efforts to determine if there's financial need, and that's why we suggest that you have a strong financial policy that really outlines what financial need is. You're going to have to do that with your provider. That's not something, you've got to get buy-in on that. If you fail to collect the patient's deductible, copay, co-insurance after making reasonable efforts, that doesn't need to be sent to collections to decide that it is a financial need for the patient. So those are some of the things that you want to consider. Again, that you would want to develop this financial hardship policy and procedure in your office. And we've seen this, that some physicians in the office will abide by it, some physicians in the office don't. It needs to be consistently applied. And we suggest that you have a list of your reduced charges per CPT code used when hardship is appropriate, and create a financial hardship form for patients to sign so that they know what their responsibilities are. They're very clear, and you might want to create a payment plan. So now I will turn this over to Sheila to go into the arbitration for the emergent and urgent medical services.
Okay, so as Susan said, in an emergent or urgent out-of-network procedure, the benefits are going to be assigned directly to the provider, and the provider will bill the carrier for services provided. The carrier then has any number of things that they can do. They can pay the requested amount within 30 days, but we all know that that's very unlikely to happen. Or they can tell the provider within 20 days that it deems that the claim is excessive, which you think that that's probably the most likely scenario. The provider then can advise the carrier of intent to reject the payment by certified mail, email, or online submission within 7 business days of the receipt of the carrier's position of the allowed charge. Now, that's part of the new proposed guidelines, the 7 days. It was in the statute, it was just 7. They had to notify the provider had to notify of the intent to reject within 7 days, but 7 days from what wasn't really clarified. Some of the carriers have taken the position that it's the date on the letter that they send out, which may or may not be sent out for several days after they draft it. But the proposed regulations that were just issued by Adobe stated that it's 7 business days from the receipt of that, of the carrier's portion. So basically, what would happen in the event of if the carrier rejects the amount that you're proposing, they will pay you the amount that they think you should get, and then after that, you can go to you can negotiate for 30 days. Or you can then you can go to binding arbitration, and the disputed amount has to be equal to or over $1,000. So if you're $500 or so apart, then the idea would be that you would not be able to go to arbitration. So basically, what happens is just to go over this because this is a very tricky provision. The carrier, you submit the claim. The carrier either pays what you're asking for, or they give the provider within 20 days whatever they think they're going to pay you. And then after that, you have 7 days hopefully from the time that you receive their letter, but that's not totally clear yet. Then to say you're going to dispute it, then you negotiate for the next 30 days, and then after that, then you go into binding arbitration. So you're already, like I would say, roughly 60 days out from the initial claim submission, at least 60 days, and that's if all of this happens. There hasn't been an awful lot that I've heard of in terms of arbitrations going on because the law is pretty new, but I think that. I think that it's going to create some of there's going to be a backlog, and I anticipate that the timelines that are required under the statute are probably not going to happen. And I would imagine that this is the carrier can use this to the fact that they're slowing up your cash flow to get you to take the lower amount. So the carrier or the provider has to notify the other party that the arbitration has been initiated within 30 days of the final offer. So now we're like 90 days out for that. And then you have to file the arbitration, which is used by the Department of Health. You each submit their final offer and a written submission explaining why. The arbitrator reviews the written submissions and selects one of the final offers. So it's sort of like a baseball type arbitration. In this very similar law has been implemented in New York and Connecticut, but they used the benchmark for payment as a standard of fair health, which they're not doing in the state of New Jersey. So it causes a little bit more work on the part of the arbitrator, and it's going to make them have to consider a lot more things, which I anticipate also is going to slow the process up a fair amount. And then the decision after you have notified the healthcare carrier and you've initiated arbitration, and then they are supposed to issue the decision after 30 days. So now we're like 120 days out, basically, from the initial claim, which, as you can see, would probably be, it can have a significant impact on your cash flow and your revenue. When the arbitrator is making the decision on making the decision about what to pay for the procedure, they have to look at things like the training, education, and experience of the provider's usual charge for the service, which I believe is part of what you have to submit when you initiate arbitration. And the circumstances and complexities of the case, the patient characteristics, comorbidities, average in-network payment, and average out-of-network payment. So you can see, if you look at this, it seems like it's a much more time-consuming process than just going with a benchmark of fair health, which is pretty easy to go for. If you just look at the zip code and the procedure, you can pretty much tell what the cost should be and what the payment should be. But this, I think, is going to slow down the whole process pretty quickly. The amount awarded when the arbitrator makes the award has to be paid within 20 days of the decision. So the arbitrator's fees are split by the parties unless it's determined that the carrier didn't act in good faith. So basically, if for some reason the arbitrator feels that the carrier's been egregious in trying to get the provider to take a minimal amount and or sort of strong-arming them, then that would be a situation where they would say that the carrier has to pay the fees. But this is not, again, the arbitration. This is really important to know, and I know this is complicated because some portions of the law apply to all providers, and some only apply to emergency and urgent medical care providers. So the arbitration only affects out-of-network, emergency, urgent, and inadvertent out-of-network procedures, and not your general, like whether there's someone. That's why we were saying that it's so important to have your documents in a row when you have a patient that's that is just making a determination to go with an out-of-network provider, that it's very important to have all the documentation really lined up with what the statute says and what the requirements are, so that you're giving the patient less chance to get out of paying the amount. But so it's not, again, this does not provide for elective services, but you can see that if the patient is not, claims that they fully don't understand, that can create an issue going forward. So, I mean, I think the most important thing is, like, there are a lot of time frames in this arbitration. As you can see, there's 20 days from this, 30 days from that, 7 days from this. You really have to have a log, and you really have to make sure that you process and timestamp and timely receipt of everything. You have to keep a log of all the issues and all of the carrier interpretations. So, like, for example, if the carrier decides that you get to notify them of that you dispute what they're willing to pay within 7 days, and they're saying, well, that should be 7 days from the date of the letter that we send out. But as long as you're aware that each carrier may have their own little spin on things, you kind of need to know how to work with that to some extent, especially if it's a big part of your payer mix. So if you find that there are things that are not that the carrier is not doing that violate the law, then obviously you can contact the carrier, or you can contact OB to launch a complaint. But realistically, I don't know how effective that's going to be. Dobie's going to be like buried under lots of stuff with this. So I would be very careful in in making sure that you have as much for your own protection from liability, and to protect your own revenue stream, that you have as much of these documents really nailed down, and really make sure that people are signing things, and all of that, so that you don't end up in a quandary with this. Obviously, there's going to be an enormous amount of additional work that comes with this. It really is going to put more pressure on the front office staff. Potentially, it's going to affect your cash flow. Potentially, it's going to, decrease revenue. And then, and with I know that I've talked to out-of-network providers who typically will say, oh, I just waive the copay, or I just waive the deductible, and you really just can't do that. This law is pretty specific on that. So some of the things that you had been doing that you kind of think are still okay, they're not. And you just need to be on top of this, because we don't really know how everything's going to spin out yet, because it's it's fairly new into the implementation of the law. But you need to be as sharp and as informed on this as humanly possible, because otherwise you can really expect to get some cash flows and revenue problems, and that's not going to be good for anybody. And make sure that you're on top of the balances of the accounts, the accounts receivable, all of those things that are going to affect your practice. So it does create a real tremendous additional burden on providers who don't need any more additional burdens, but that's kind of what we're stuck with right now. And I wish I could be giving you better news on this, but right now this is what the law is, and it does require a lot more labor-intensive work from the medical practitioner and their staff to make sure you're in compliance with all of this.
One other thing that I'd like to say is that you might also want to do is look at your fees and what your schedules are in comparison with Fair Health for your demographics in your region, and how far off are you? Are you 200% off, 100% off, 400% off, 10 times more, 20 times more? You really need to take a look at that too, and see what the UCR is and how far off you are from that.
So I think that's all we have. If there are questions, please. I'm sure we've overwhelmed you with a huge amount of specific information, but you can certainly contact either me or Susan to follow up with questions afterwards. But we're happy to take questions now.
We do have a few questions. The first one is it the physician's responsibility to alert the patient of out-of-network status while rounding on a patient who was admitted via the ER? Our physicians never look at what insurance the patient has.
Are they talking about for emergencies? Emergencies are different. So we talked about emergency services and what can be billed and not be billed.
But the idea in the law is that you really are supposed to notify the patient, as soon as possible, which, when you think about it, kind of really doesn't make any sense, because you've got, a patient in the ER and maybe that patient's family, and everybody's all upset, and, the patient may not be feeling that great, or, may have had sedatives or painkillers or whatever. So it's not really a situation where they're going to be fully capable of making some kind of a real universal decision as to whether they want to use you or they want to use somebody else. But the idea is that they are supposed to.
After they're admitted.
Okay. So if they're admitted as an inpatient, certainly that's the time that you want to have, you want to be able to inform them as soon as humanly possible to get that network status and make sure that they're aware of it and what their rights are. So it can create a complicated situation.
And we're hoping that when the regulations come out, some of this stuff is made more clear and ironed out. But right now, I would err on the side of caution and inform them as soon as possible if they're now an inpatient and you're rounding on the patient.
Okay, the next question, why would you want to opt into the Act for a self-funded plan?
I don't know that they would. I don't know why you would want to. I guess because it potentially gives you access to the arbitration proceeding and everything. And if you don't want to, if the self-insured plan doesn't want to pay, or they may see it as a cost saving benefit to them if they can, kind of slow things down and go through the arbitration procedure. That might be a benefit to the plan. That's really what I could think of.
Yeah, and because it decreases the liability of the carrier for all of this. The other thing is that we didn't mention, and not going over in any great detail, but for out-of-network plans, self-funded plans, there is a provision for the patient to actually go to arbitration.
There is a provision in the law which we think is kind of weird, because once the patient assigns an out-of-network benefit to the physician, it should be either the carrier or the physician that's initiating arbitration. But there is a provision in there allowing a patient to submit for arbitration also, which we're not. Again, this is all new, so we haven't seen any regulations on this, and we're not quite sure under what circumstances that would happen. But you can kind of guess that might happen in a situation where a patient is saying it was an emergency out of network, and that I wasn't properly informed, and this really was not a knowing and voluntary. I mean, you can see it. I don't think that it's been advertised significantly to patients, but there is a provision in the law that says that they could do that. So we have to look and see what happens with that.
Okay, the next question is, can you give them a range of EM codes for the estimated amount we don't know until the provider renders service?
Well, I guess, so there might be some, you can give them codes that you think reasonably are going to apply to them, but you may not know everything until you actually provide the service, and there may be things that crop up, during the service that would mean that you had to add on something that you didn't anticipate earlier. So I think you could probably do okay with giving people, this is what we think is going to happen, but that should be part of your disclosure also, that there would be, that there's a possibility that there may be unplanned circumstances where you discover that you really have to do something else too, and you need to cover yourself in that event.
And I suggest that also that be made clear on the disclosure form. So you can put that into the disclosure form that this is an estimate, and where we don't know everything until you are actually examined.
When a patient has surgery in a hospital that requires anesthesia, we don't know who the on-call anesthesiologist is. We inform the patient of this information. What more should we do?
It's also up to the hospital. If we didn't put in anything about the hospital here, but it is also up to the hospital if there is an out-of-network anesthesia or radiology or whatever. They have to disclose that to the patient as well.
Yeah.
So, from the provider's standpoint, I would direct them back to the hospital to ask that question.
The key question is, how do we determine whether a patient's insurance is covered by the Act? Specific wording.
Well, I mean, any of the private carriers like Horizon, Aetna, AmeriHealth, they would be likely to be state regulated. I think, you know, you're probably better off doing this with everybody and not limiting it to, you know, not dividing it out by plans, because I think that's just going to make your life much more complicated. You're much better off advising people, whoever comes in, that this is what our policies and procedures are, and having everyone sign off on it. I mean, generally, I would say, you know, as a rule of thumb, if it's Medicare, Medicaid, workers' comp, or PIP, or something like that, then that's not an out-of-network issue. It's specifically excluded by the law, but realistically, it's going to make your life a lot easier if you have one set of documents for everybody to have and to sign off on.
And that's why we put that slide in there about that this should be uniformly and consistently applied, because at this point you may not know, you know, everything. And the guidelines that Sheila gave you are very good about, you know, workers' comp, Medicare, Medicaid, but the rest of it you may not know. So be as consistent and uniform as possible with your policies and procedures in the office, and it shouldn't vary between provider.
Many insurances do not have participation status, example, commercial insurances. If there's no such par/non-par status, does this law cover?
We didn't hear that, Alex.
You were breaking up.
Many insurances do not have participation status, such as commercial insurances. If there's no such par/non-par status, does this law cover?
We didn't get the.
I'm sorry, we didn't. You broke up a little bit again.
Okay. Many insurances do not have participation status, such as commercial insurances. If there's no such par or non-par status, does this law cover?
I guess I'm not quite sure what they mean by that. Do they mean that there are no out-of-network benefits for like an HMO plan? Because if there's no out-of-network benefits, there's no out-of-network benefits. But
yeah, the law only covers what it applies to what the insurance plan actually covers. If it doesn't cover a service, then it doesn't apply.
Like you can't do an elective out-of-network surgery with, you know, something that's elective and out-of-network in an HMO. Obviously, if it's you know, if it's an emergency, that's different. But I would say, as a rule of thumb, that again, you want to I would just assume, I would err on the side of caution and make an assumption that everybody's covered by the law. You know, except for those few that I mentioned, because it's, you know, it gets very complicated. And I think if you're trying to, you can spend a huge amount of time and effort trying to narrow everything down and having different forms and different policies for different insurances. But realistically, I just don't know how manageable that is in a practice environment.
Okay. Blue Cross Blue Shield is notorious for paying the patient, not the out-of-network provider. If the patient receives the EOB or check and does not deliver it to us within the allowed number of days, what happens?
Same thing that happens now. You got to chase them. Yes, and they are notorious. I agree. But especially with out-of-network, they really don't like to pay out-of-network benefits. So, yeah, Horizon is a major offender on that. But yeah, I mean, basically, you have to do what you have to do now is chase the patient and try to get the money back from them.
Okay.
Arbitration. But under the new law, the payment is supposed to be made to the provider. But again, we don't really know how that's going to work.
And we don't know what the insurer is going to decide to do.
Okay. arbitration not available to the patient that selects an OON provider, or is it only when elective services are selective?
The arbitration for a patient, it's, you know, the law is really not clear on when the patient can elect for arbitration. So I think what I had said before was just sort of my assumption or like, you know, of where it might be used, but we won't know until the regulations actually come out if that's actually going to be part of it. The whole, other than saying that the patient can elect for arbitration, the law doesn't really describe the circumstances under which a patient can elect for arbitration and doesn't really describe the process. So I would think that it would come into play where someone was saying, no, in fact, this wasn't a voluntary out-of-network procedure. This was emergency or urgent. But again, that's just my best guesstimate.
Okay, is the $1,000 per claim, or can you aggregate?
Per claim.
It's per claim.
It's per claim.
Okay, and how does it pertain to specialties such as anesthesia groups post-ER admit?
It would apply the same. The law applies the same. There's no difference. If they're out of network, they're going to have to do all the same things that, you know, anybody else would do.
Okay. How does this affect patients who do not have out-of-network benefits and the carrier will not pay at all?
The law doesn't apply to if they have no out-of-network benefits. The law only applies to what the health benefit plan would cover if there are in-network services available.
So if a patient decides to has you know, an HMO or has no out-of-network benefits with their plan, and they decide to go out of network for whatever reason, then they're on the hook essentially. The only time that you would have an out-of-network benefit would be in an emergency situation, as I understand it.
Okay.
We are an in-network specialist, but we prefer to use an OON lab. We need to disclose all related expenses to the patient before drawing the specimen.
Yes.
Yes.
Okay. Does this apply to Medicare Advantage plans?
No, I think the Medicare Advantage plans are specifically excluded.
I'm not sure yet, but I think it would be excluded.
Yeah, I mean, they're a little bit of a hybrid because they're both Medicare and commercial insurance. So it's a little bit of a hybrid. You know, we can check up on that and let you know, Alex. But I believe that I would anticipate that they're excluded.
Includes Medicare Advantage.
Yeah.
Okay.
So I'm pretty sure that it would not be included in the law, but I can see that there might be something tricky with that.
Okay, and the last question we have for today is, if the patient elects arbitration, do they pay for half the costs?
If the patient, we're not sure what happens when the patient elects arbitration. The procedure really that they set forth in the law is more about what happens between the carrier and the provider. There's just some verbiage in the law that says a patient can elect it, but if they're going to say that if the arbitration procedure is going to apply to patients the way it is now, then yes, I would say they would share costs. But
okay,
again, we don't really know because the regulations haven't been issued yet.
Okay, we got one more question. What happens if we see HMO patients with no out-of-network benefits emergently and insurance does not pay our fee? Is the insurance supposed to pay based on the in-network benefits?
Well, I'm not sure actually. If it's an HMO and you see a patient on an emergent basis, I don't know that the practitioner is limited to just the payment under the HMO. And I think that probably is going to be specific plan by plan as to what they provide. And it's not really an out-of-network issue, but generally the HMOs, or the managed care type of plans that don't provide for just elective out-of-network benefits, do provide that if someone is it's an emergency situation, that they will cover costs, but I wouldn't want to guess as to how much of the cost they would cover. I would make an assumption as little as possible.
Any other questions?
Nope, those are all the questions that we have. And if anyone has any additional questions, you can reach out to Sheila and Susan. And don't forget that our payer seminar is on Friday, and this presentation will be emailed out to everyone following the completion of the webinar.
Great.
Okay, have a good day, everyone.
Thanks, everybody.
Bye-bye.
Bye-bye.